FOX6 appearances.
Sarah Sadowski appears for the state. Good morning.
Timothy Olson in custody pro se, was in the courtroom moments ago and is now in the holding cell or bullpen area. Attorney John Wasilewski appears as standby counsel.
Right, good morning to everyone. Before the case was called, Mr. Olson was brought out and seated at defense table. I could see and hear that he was talking to standby counsel, and so I allowed that to continue without calling the case. The court then inquired if more time was needed. The intention would have been, if more time was needed, it would be more appropriate for Mr. Olson to be taken back to the bullpen so that he can continue his conversation with standby counsel. Mr. Olson then responded without invitation of the court. It wasn't meant to invite him to respond to that. It's just a matter of the court determining logistics and timing. And so Mr. Olson, being disruptive, was then ordered to be removed from the courtroom, and he, on his way out, proceeded to continue to talk despite the court's order that he not say anything. My question, though, Attorney Wasilewski, in that Mr. Olson has prepared additional motions. If you could just take a look at it to see, from what you can tell, what type of motion it is, and the question is whether it needs to be addressed by this court, if it's a matter more appropriately to be filed with the Court of Appeals. At this stage, of course, we've yet to go to sentencing, but at this stage, there are a limited number of motions he can file, and so in an effort to not waste the court's time, if it's not a motion that the trial court can entertain, then I can then instruct Mr. Olson, pursuant to statute, to file with the appropriate office, whether it's with the clerk of courts at the trial level or with the Court of Appeals. But I don't think it's necessary for us to go into details if it's not appropriate for the trial court to address it. So we'll go off the record if you could do that. We're going to wait maybe another 10 minutes to allow Mr. Olson to calm down. I'll bring him out here again. I'll give another warning. If he fails to follow the court's rules, we'll just have to repeat this process whereby he's taken back there and allowed to calm down before we can proceed. It is sentencing. He has a right to be here. And so that's the best that the court can do at this time to ensure that we're able to complete sentencing, but also in a manner that is consistent with the court's rules of decorum. Okay, we're off the record. Okay, any trials that we can do first call on?
We still need defense attorneys. Attorney Flynn and Attorney Mathias.
State, in this case, I didn't see anything.
Sadowski appears for the state.
Timothy Olson is present in the courtroom, in person, in custody. Standby counsel John Wasilewski also appears.
I'm objecting because my microphone is off, just like she turned it off during trial, so I couldn't object.
Mr. Olson?
I'm objecting. You
I'm
can't turn
gonna-
my microphone off.
Okay. This is the second time I'm trying to have this case called. If you interrupt me, I'm going to have you removed, okay? This case proceeding is not for you to control.
But you
I've already
can't-
explained that. Okay,
I have to be
Now,
allowed
Mr.
to
Olson?
speak, Your Honor.
okay, we're gonna have you removed until you can comply with the court's rules of decorum, which you are aware of. Do not speak over one another. You are to wait until the court asks you a question. We can barely get through appearances.
You're violating my rights.
Okay. Remove Mr. Olson.
like you did
You'll be
throughout
given
the
another
trial.
15-minute break, and then if you can comply with the court's rules, you'll be brought back. It's 9:28.
You're violating every code of conduct you can think of. You're not going to violate my rights.
Okay, we're back on the record in the Olson matter, just so the attorneys are aware. The court will give him another chance, and if he continues this, we will then put him on Zoom, and he can appear on Zoom for sentencing. To ensure that he's going to waive his right to appear in person should this behavior continue. So, to that end, the legal parties can then prepare accordingly for a Zoom appearance in the event that Mr. Olson does not comply with court rules. Okay, we're off the record. Is the Zoom setup still back there, or did Mike Poof take it out already? Okay, can we, Nate, can you get Mike Pook here? Yeah. To the laptop or to Zoom? Okay. Yeah, that I don't have either. And it's the same set as you talked about. was back there where the laptop is outside the whole, really outside the cell. Okay. Okay, great. We're gonna give her one more chance and we'll see where it goes. He said he can? Okay, great. Oh, yeah, no, Nate was able to get a hold of him. Thank you. Any of those other cases can be called?
Mr. Lee? Yes. I sent you an offer, right? Seems like you're very relaxed.
It's been more than 15 minutes. Is Sharma coming? Is it going to go to trial? Okay, well, if she's out there, we need to call the case. She's here. Let's call that case. For first call, although Attorney Lassie just left, I want to know what the status is of his other case. Morning.
What's the plan?
State of Wisconsin versus Timothy Luther Olson Jr., 22 CF 4696. Appearances again.
Sarah Sadowski appears for the state.
Hey, I'm
Timothy
grabbing the
Olson.
microphone. What are you doing?
Okay.
I'm gonna ask that you ask your deputy not
Olson?
to assault me. I was grabbing the microphone.
Okay.
It's unnecessary.
Mr. Olson, you need to stop.
It's
Will be
unnecessary though.
removed. Okay. Appearance, please.
Appearances, Timothy Olson appears in court, in custody, pro se, in person. Is it, standby counsel John Wasilewski also appears.
All right. Good morning to everyone. This is the third attempt that the court is trying to have this case called. We finally got past appearances just now. It's now 9:57. I did have Mr. Olson removed at 9:28, so more than 15 minutes was given to Mr. Olson to calm down. Mr. Olson, I'm letting you know that if you fail to follow the court's rules of decorum and you continue to be disruptive, I will have you removed and you will appear on Zoom for sentencing so that the court can okay. I'm not done talking. I'm letting you know that your disruptive behavior, if it continues, will result in your removal. It does not prevent the court from continuing with sentencing, and I intend to complete sentencing today. You will appear on Zoom.
May I
All
speak
right.
now?
No, you may not.
Okay, I'm
Because-
objecting.
Okay, Mr. Olson, I'm going to have you removed,
I'm
and
just
you're going to appear
objecting.
on Zoom.
Hey, can you make sure this either goes with you or goes into the file? That's this is the envelope full of the three flash drives that I have to have it analyzed.
We're off the record.
Did you put those into the, okay, hold on. Did you put those on the file? The motions?
No, I removed from court, you need to stand up now.
Mike, who's back there?
He did come in.
Mike, who's back there?
He did come in. I'm not sure if he's still
Okay.
back there.
I did let in 6:35.
That was my son.
The video is, the camera is blocked. Or covered, I mean.
The tune is for.
Wait, do you
Attorney
need the
Flynn's.
TVs turned on? Do you have the control over there? Is there a client able to appear on Zoom? Okay. You have good contact with him? Okay. Okay. You want to call it then? As soon as, is that Attorney Elderkin on that case with Gaines? Oh, Lonsky. Okay, Attorney Lonsky's here. Attorney Lonsky, we can call Gaines. Okay. No, after I ask Attorney Lonsky to speak, we need to let Attorney Lonsky in. Yeah, after that. So after Attorney, after I ask Attorney Lonsky, then he gets the money back. I want to place that on the record, so that way there are no allegations of mishandling. All right.
I've seen him on Zoom from Dota, but I haven't had any.
Attorney Lonsky, we are calling Gaines from yesterday. Going on the record for Gaines from March 16th. State of Wisconsin versus Quartarius Gaines, case number 25 CF 3006, appearances.
Okay, back on the record in State of Wisconsin versus Timothy Luther Olson Jr., 22 CF 4696. Appearances again.
Sarah Sadowski appears for the state.
Timothy Olson is in custody, pro se. He is visible on the Zoom screen in the holding cell behind the courtroom. Attorney John Wasilewski, standby counsel, also appears.
All right, good morning to everyone. Due to Mr. Olson's continued disruptive behavior, which prevented the court in proceeding with the sentencing, he was removed and now appears on Zoom. His audio on Zoom is muted and will be unmuted when it is time for him to speak. Okay, so before we go any further, I had asked Attorney Wasilewski to just look at the new motions that Mr. Olson has prepared and wants to file with the court. I think as a matter of procedure, in terms of timeliness, what are those motions, counsel? Have you had a chance to look at it?
Yes, I have not read them word for word, but I have viewed them enough to have an overall feel for what they are. There are two documents. The first one is 14 pages in length. The second one is 20 pages in length. They all purported to be directed not only at the circuit court, but at the United States Supreme Court, the Wisconsin Supreme Court, the Wisconsin Court of Appeals. In addition, the 20-page document is purportedly addressed to the Federal Bureau of Investigation, the U.S. Attorney, and various what are characterized as internal affairs departments. Each of them contains at least 20 numbered grounds. Some of them are in a single sentence, some of them are a little longer. Most of these grounds allege improprieties or misconduct both before trial and during trial, improprieties or misconduct by the court, by the prosecutor, by me, by various court personnel, by prior counsel. That would be my summary of what I reviewed.
Okay, so now that I know that, I do want to circle back and go to, I'm going to refer to them as document 170 and 171, but those are the two motions that Mr. Olson wanted to file on Saturday when we were in trial. They have since been filed. The 15-page one-sided or single-sided motion is document 170. The 2-page is document 171. I have read those motions, and Mr. Olson, you are the movant, and so I'll give you an opportunity to place on the record explaining what you're asking of the court and the basis you have for what you're asking, and you're to limit what you place on the record on that. If you go off on a tangent, you start talking about something else, I will mute you and then we'll continue. But I'm letting you know that your continued failure to follow the court's rules of decorum, including when the court directs you to pay attention and focus on what's at hand, will result in your Zoom being muted. Okay, so at this time, let's have Mr. Olson unmuted, and I want to go one motion at a time. The first motion is the 15-page single-sided motion, which I refer to as document 170. That is the white packet here. The other one is the yellow paper here. So let's start with the 15-page on white paper. As to your motion, Mr. Olson. Hold on, you have to be unmuted. We can't hear you, but I can tell you're trying to say something.
Okay, hello?
Yes, we can hear you.
So I would like to ask that those copies of those motions be brought back to me so that I can go over them, because I don't have copies of them. I was not able to make copies because of you placing me in the hole.
Okay, hold on. Yep, we'll bring it back.
I would ask that all.
Mr. Olson, just wait until you have your motions. Okay, so starting with the white 15-page motion.
Yes. Okay,
Go
I
ahead.
just need to clarify for the record that this 15-page motion was submitted, I notified the court on Saturday, March 14th, prior to my testimony that this needed to be submitted. The second motion was the one I wanted to submit later on, but the court made it seem as if the 15-page motion was submitted after,
Okay, let me direct your attention, Mr. Olson, because you're not really answering my question relative to what you want to put on the record in support of your motion. As to the 15-page motion, what are you asking of the court?
I'm asking the court for a mistrial and to dismiss charges.
Okay, and then the support for that.
Well, the jurors were talking in the hallway, at least 8 of them, in front of the elevator. They actually tried getting on the elevator with me. Several of them, they were all in the hallways talking about the case. Your deputies were talking about it. I know for sure Deputy Rivers was texting about the trial during the trial. This was on 3/11 and more days than that, but for sure I heard him talking about it then. Also, I noticed that the DA and yourself were communicating via cell phones during my trial with texts and calls. I was also informed by other clients of P.I. Thomas Fisher that the DA was informing that the DA informed Thomas Fisher that she was bribing you to conceal the text and misconduct that she's been committing, and I'm asking that this be fully investigated by the FBI. All phones, yourself, DA Sadowski, your deputies, and the jurors, including Attorney Wazalewski, these phones need to be downloaded, and this needs to be fully investigated because this is very serious. And the text that exonerating exists, and the DA perjured herself on June 16th when she asked Attorney Wazalewski if he received the redacted version of the phone download, then claimed there was never a redacted version. And on, I believe it was October 24th or November 24th, the hearing in November or October of 25, the DA refused to answer what she gave Attorney Conradi on February 14th, 2024, when she gave over the unredacted phone download, which the DA and the detective claimed there was no unredacted version and you couldn't redact or unredact. This is all one big lie, and it's provable by perjury committed by both of them during trial testimony and transcripts that I had requested. And DA Sadowski intentionally gave us flash drives that wouldn't open, and Attorney Wazalewski testified to this in court that he tried it on his computer. Now, these are because permissions can be given to open those flash drives on other computers or not given. This is why they wouldn't open for us, and it would open.
Okay,
for
Mr. Olson, I'm going to stop you there for a minute. In all fairness to the state, who has to respond, or they don't have to respond, but they will be given an opportunity to respond. And having read your motion, you should not bring into your motion new things that you did not give notice to opposing parties. So to the extent that some of the things you're talking about are not contained as part of your basis or support of your motion, try not to talk about those things, okay? All right, continue and try to sum it up, because I'm going to move on and have the state respond, and when I do that, I'm going to have you muted.
All right. the deputies, were purposely parading me through the hallways instead of going the back route. Any other time before trial, we never went through the front like that, but all of a sudden during trial, I'm being paraded through the front. Even during a medical emergency, I would walk out through those hallways, with puke-covered clothes. I was incoherent, and this is one of my main, reasons for a mistrial. I was brought into the courtroom, and they knew I was incoherent from puking in the back. I had a seizure in the back when a different deputy, it wasn't Rivers or Bruce, were back here. I had a seizure in the wheelchair. I was driving. They knew I was incoherent in the courtroom. I was not even able to object or respond because of the severity of the concussions. I'm not positive, but I believe on Wednesday, the 12th of March, during the third day of trial or second day of trial, I believe I had another seizure in the cell and made the head wound on the head worse, which is this is when Sergeant Wilborn took pics of my head wounds on
Okay, Mr. Olson, I'm going to have you muted. And now that you're muted, I'm going to invite the state to respond. In reading document 171, which is the 2-page yellow paper that you also filed, you provide mostly, if not all, the same basis for that motion that you did for 170. So I'm going to turn to the state and allow the state to respond as it relates to the motion to dismiss and or in the alternate motion for mistrial. To the extent that document 170, which is the 15-page, is addressed to Chief Justice Jill Krafsky and other entities and organizations, but other entities. But I think to the extent that it could be interpreted as a petition for supervisory writ, the trial court is not the proper forum for that. That should be filed under should be filed with the Court of Appeals under 809. And so setting that aside, construing 170 and 171 together as a motion to dismiss or in the alternate motion for mistrial. State your response. If that makes sense, what I'm saying for the record. There's a lot of people who are named and many people who these motions are addressed to. 170, I think, could also be interpreted as defendant's petition for supervisory writ, and to that extent, trial court is not the proper forum.
Right. And I was going to say, none of them necessarily seem to be addressed to this court either way. Additionally, none of these, Mr. Olson was able to verbally argue all of this in his motion at the close of evidence. So I think also these are untimely, even if we would have addressed them before the final verdict. So there's no new information here. This is untimely. It wasn't addressed to us. It's not the proper forum. It's after the judgment of conviction. And frankly, parties cannot make wild claims without any factual basis. And so I think that is also a reason that these should either be that these should be dismissed or they can be filed for review upon a different court.
Okay. In trying to make sense of these motions, it's clear to me that Mr. Olson is unhappy with the trial court's decisions. And he's certainly entitled to be unhappy. As a matter of fact, many times people are unhappy with decisions of the court. But by no means does that mean that Mr. Olson can repeatedly ask the same court to reconsider its decision. And so I think another angle of this is that to the extent that Mr. Olson is requesting the court to reconsider its own decision, he doesn't provide a legal basis for which the court can do that. Many of the grounds or bases that he provides in support of his motions, whether it's document 170, 171, are bases or allegations that the court has already addressed previously. At milestones of this trial, Mr. Olson was invited by the court to make any motions of the court, and the court specifically at the close of the state's case in chief indicating that this is a sufficiency of the evidence standard, and then again at the close of all evidence indicating that it is sufficiency of the evidence. That being the case, the grounds for which Mr. Olson puts in support of his motions do not address the sufficiency of the evidence, but are more along the lines of his grievances towards the trial court, as well as anyone else who's touched his case, whether that involves prior counsel, standby counsel, or the state. And thus, these motions are untimely, and the trial court is the improper forum relative to document 170. And I think the court has on more than one occasion has been willing to entertain Mr. Olson's motions, but it has simply come to a point where enough is enough. This has just been another tactic of Mr. Olson to delay the court in closing out this case, especially now that we're at sentencing. And so for all those reasons, document 170, the court will, even if it's not construed as a petition for a supervisory writ that must be filed with the Court of Appeals, that motion, if it's construed as a motion to dismiss or a motion in the alternate motion for mistrial, denied by the court. For all those reasons, the court placed on the record document 171, the two-page motion, also denied for all those reasons placed on the record. With respect to the unfiled motions, it sounds like to me, based on the description given by standby counsel, for purpose of the record, we can pull it in, but the court's not going to address it because many of those grounds and bases sound like the same grounds and bases provided for motion document 170 and document 171. To the extent that Mr. Olson can raise those issues on appeal, he may do so, but I think for completeness of the record, those motions can be received by the clerk, and the clerk may receive them and file it in the record, but the court will not address them for all those reasons. Okay, so now we're going to move on to sentencing. And State, are you complying with victim notification?
Yes, we have victim notification of all victims. There is no victim impact statement that the state is filing at this time or restitution request.
And just so we're all on the same page, I did go through the counts, and I'm confirming with you, State. Count 1 is a Class C with an enhancer. By the way, I sentence in months, just so you know.
I'm sorry, what was that?
My sentencing, I do it in months, not years, just so you know.
I did not know that, so.
Okay, but for the purpose of the record, and to be consistent with what's in the information, count 1 is Class C with an enhancer. Initial confinement for Class C is 25 years, enhancer is 6 years. So the total initial confinement, the maximum is 31. Extended supervision is 15. The total imprisonment for count 1 would be 46. I'm just going over the maximum. Is that correct for count 1? So it's Class C, 25.
Yes.
And then the enhancer is 6.
Yes.
So that gives me 31.
Yes.
And then extended supervision is 15. The total imprisonment, initial and so the bifurcated, would be 46. Did I get that right?
Yes.
I can't. Let me double check my math. That's why I always like to do. Yes, 46.
But you would prefer that.
And those are in years. So in months, that would be 552 months. Yeah. So if we were to break that down into months, it would be the total initial confinement with the enhancer is 372 months. Extended supervision is 180 days. And total imprisonment, the bifurcated imprisonment would be 552.
Yes, you just misspoke briefly. You said 180 days for extended
Oh, I'm sorry,
supervision instead of
180
it
months. Yeah.
Yes, okay.
There are no days. We do it in months here. And the reason why I do that is because the written explanation and determinate sentence, I can do it in years or months, but sometimes, there are no years. So it's just easier if I do it across the board in months. That's why I do it this way. It's not to try to, unnecessarily burden anyone, but it's just easier for me to do it in months because of the worksheet I ultimately have to use.
That's fine. I'm just doing some calculations myself. Thank you.
Okay, and then, so state you concur with the maximum as how I just calculated it?
Yes.
Okay, then moving on to count 2, class H, initial confinement is 3, enhancer is 4, which takes us to 7 for initial confinement and years. Now, I'll first do years and then I'll go to months, with exception that count 3, that's a misdemeanor, so we're not talking years there. Extended supervision will be 3 years, and so total imprisonment for the bifurcated sentence maximum would be 10. And months, that would be initial confinement 36, enhancer is 48 months, with a total of 84 months, and extended supervision would be 36 months, and then the total bifurcated sentence maximum would be 120 months. Count 3 is a class A misdemeanor, 9 months. And then count 4, beginning with years first, 7.5 years initial confinement, 5 years extended supervision for a total of 12.5 years imprisonment. Again, that's a class F. And then in months, that's 90 initial confinement, 60 extended supervision, 150 maximum for in months. And then count 5 is the same thing. 12.5 years maximum total imprisonment bifurcated, or 150 months total bifurcated, with the 90 and 60. 90 initial confinement, 60 extended supervision. Okay, so I think I did the math correct. State, do you concur with that?
Yes.
Okay, and then Attorney Wasilewski, to ensure that the court is doing the math correctly, would you concur with all of that as well?
I would concur with all the year calculations. I haven't done the month conversions, but the years were correct that I was following.
Okay. All right. So now that we all have that as a starting base, so that Mr. Olson, it's really for Mr. Olson's benefit so he understands what the maximum is, but state at this time with respect to your sentencing argument.
Thank you, Your Honor. I just want to say one thing. I'm not going to talk about the facts of the trial in great detail. We were all here just last week going over the facts of the trial. But what I think is important to do is to fill in some of the gaps that were not talked about during the trial. And when I say that, for example, one thing that sticks out to me greatly was a discussion of why and some of the locations where Mr. Olson and Ms. Hannah were driving around the city. Detective Zaleski and frankly many other people in this community reached out regarding determining the identity of Mr. Olson. And so that is where I start basically this sentencing argument and why I think this is important. As I talk about the seriousness of the offense, the character of the defendant, and the need to protect the public. As we all know, Ms. Hannah was now, we can say, as the jury convicted, was abducted on the night before Thanksgiving in 2022. The next day, when she was recovered by police officers, again, this was a bit disturbing. The initial responding officers from Greenfield, and I've had discussions with them about this, truly did think for a moment that this was someone suffering from some of the more unfortunate effects of old age. But what we are all grateful for is that an investigation continued, that even Greenfield officers didn't just give up on this and walk away. As the story kept coming out, they realized that something happened, and the investigation carried on. So the next thing that happened in the investigation was that it was determined that Ms. Hanel's credit card was used not just at 1 or 2 locations, but a minimum of 5 locations across Milwaukee County that were discussed again at extent during trial. The video that was obtained from 2 of those locations that was shown during trial, that was broadcast through other law enforcement agencies and via the media. The media was also interested in identifying a case in South Milwaukee, which happened on November 17th, 2022. That case in South Milwaukee had Mr. Olson and an individual who is now deceased walk into a bar together, a drinking establishment. And it was shown on video and on the media that this individual, the victim, or not Mr. Olson, female, lost consciousness in the bar and later passed away. That image was also being broadcast throughout the media at the same time. This led to several tips of the identity of Mr. Olson, as he was, for lack of a better term, connected to several crimes, alleged crimes, throughout southeastern Wisconsin and into northern Illinois in fall of 2022. Some of the facts in this trial that were discussed and then avoided: there was allegations of Ms. Hanel being on the north side with Mr. Olson due to the purchase of illegal substances that Ms. Hanel told officers. Ms. Hanel and my investigating officers were directed not to talk about that because I think that was not charged, but that was some of the allegations why there were many, many stops all over Milwaukee County for no discernible reason for the trial. But I think that's important context for Your Honor to have. Now, mind you, Your Honor, I'm talking about things that have not been charged. So, of course, I know that you will give them the weight to which they are due during this investigation. Additionally, it was discussed at the trial, Casa de Giorgio, where Rex Adrizi discussed Mr. Olson leaving without paying his bill. That was actually where several of the tips came from for law enforcement regarding the identity of Mr. Olson, as Mr. Olson had made a habit of going to an establishment, ordering a meal, and then leaving without paying. Many of these establishments, which was turned over in discovery, which, as you know, the state turned over a full copy of discovery, led to the identity of his face, of his features in these establishments. So again, this is all going to the character of the defendant and what he was doing. And I think that in this scenario too, he was realizing that he was closer and closer to getting caught, closer and closer to getting picked up by police, in which he was on November 29th of 2022. The other incident that I think leaves a lot of context out is, and was discussed briefly during the trial, was during the cell phone download. There were a lot of searches for Mr. Olson's mother's name, her in association with Racine Police Department, her in association with CCAP records. And that's because then on November 8th in 2022, Racine had investigated a death investigation because there was an individual that was found deceased in his mother's home after being out for a night with Mr. Olson. So this was another individual associated with Mr. Olson that ended up deceased in close proximity with meeting him and going out with him. And those are uncharged cases. Racine County also has 2 charged cases that I would also like to reference. These cases, Mr. Olson has yet to make an initial appearance on in Racine County, but they are first case number 22CF1503. Your Honor, this was referenced. There are 5 counts of personal ID theft for financial gain, where again the allegations are that the individual was an adult that met Mr. Olson online, ended up going out with him, ended up being what was described as roofied, and then having her credit card be used at a number, well, at least at 5 charge locations in this complaint. Additionally, in case number 23 CF 43, conduct that happened on September 16th of 2022, this individual, again, was out with Mr. Olson, complained again of being given something which altered her mental state. That complaint alleges a number of controlled substances in her system which she denies taking, and she was sexually assaulted. In that case is charged as a second-degree sexual assault of a person incapable of giving consent due to being under the influence or an intoxicant. Some of the allegations continued in identifying Mr. Olson. We had some individuals reach out stating they had met up with him regarding the buying and selling of illicit substances. It's just adds so much regarding his character, regarding the need to protect the public, regarding the effective rampage that Mr. Olson was on during this time frame. It's difficult to imagine how this could have happened over and over again. Additionally, Your Honor, there is one consequence that when we're in trial today, that when we're discussing the trial that happened last week, when we're discussing the victims from last week, there's one consequence that, to me, it's difficult to think about, and in a way that it doesn't come top of mind. And what I say about that is, as you know, Mr. Olson has an extensive criminal record, and I'll run through that briefly because I think it's important to have that during the sentencing argument. In 2002, he was convicted of possession of drug paraphernalia in Racine County. In 2012, theft in Kane County, Illinois. In 2009, driver-operated vehicle without owner's consent. In 2007, a burglary in Illinois. In 2005, resisting and obstructing in Dane County. In 2005, possession of cocaine or controlled substance in Dane County. A felony theft conviction in 2004. A forgery from 1997, where he was convicted in 2000. A felony theft in Kenosha County from 1997. An escape from 1997 in Kenosha. 2 counts of forgery uttering in Kenosha in 1994. And then when I reviewed with carefulness his in-custody time through Illinois and Chicago, it is clear that Mr. Olson has been spending his time in custody by the installment plan, not having much more of a gap in custody than like approximately 3 or 4 years, several years in a row. And while I want to talk about his conviction now, is I'm bringing up specifically a case number 06CF5944 for 2 separate reasons. One, that case was discussed during trial because Mr. Olson stated, part of that was concealed because of misconduct. Part of his character also goes to the fact that he doesn't believe that your court, defense attorney, or I can fact check or inquire as to what actually happened in that case. And while I think the reasons for that case being resentenced are appropriate for not being put on the record, it wasn't misconduct. It wasn't those allegations. And why I'm also bringing up that case is that our general DA mailbox received an email from the victim of that case, partially just discussing the trial as a whole, but partially discussing about the fact that even though this was 20 years ago, and she thought she had put this behind her, seeing Mr. Olson's face on television day after day after day For now, Your Honor, it's been almost 2 weeks since he first claimed competency that he has been on the news and on the media, and that she's sitting in her home, and this ends up basically invading her living room, about how this brings up her past and how she is still to this day devastated, embarrassed, and ashamed, and in shock that she could have fallen prey to this evil person. She's brave for still being here, for reaching out, for discussing that. Every victim, every witness that came forward in trial last week to talk about what happened, to talk about their story, is going to have those same effects for a long time. I think it's important to bring up because this victimization isn't just a one-time done. This lasts with victims, especially when they're taking advantage of in this way, for years. And I think, Your Honor, that's one of the reasons why the need to protect the public is so high and why the seriousness of this offense is so high. And I would like to discuss now exactly what I am asking for in months from each of the counts that Mr. Olson was convicted of. For count 1, kidnapping, and Your Honor, just to be clear, I'm going to ask Your Honor for consecutive sentences for each of these counts. They are all separate. They all have separate victims, are separate crimes with separate types of motivations by Mr. Olson. While counts 1 and 2 are the same victim, they are very different crimes with very different consequences. For count 1, I'm going to ask for 264 months in custody with 180 months of extended supervision. Count 2, 36 months in custody with 36 months of extended supervision. Count 3, 6 months in custody. And for counts 4 and 5, I'm going to ask separately. So count 4, 60 months in custody and 36 months extended supervision, and then the same for count 5. Frankly, Your Honor, this is as close to what the state believes a case should be deserving of for a maximum sentence. And the only reason I am not asking for a maximum sentence is 1, because Ms. Hannell was allowed to escape relatively unharmed, even though it has taken her years and years. Well, frankly, she states she still has a nightmare every night. Though that was her testimony. This is still causing her nightmares every night. So I guess physically unharmed would be a more accurate way to put it. And regarding the burglaries, those types of allegations Mr. Olson's faced in the past, has been convicted of in the past. The only reason I'm not asking for a maximum sentence on those is that it was not the primary residence that was fully broken into. Although, of course, with the Endall home, that is part of what caused Ms. Endall, Christine Endall, to have such trauma, is that she could tell that her home was attempted to be broken into, and that was an incredible violation of her sanctity, her security, and how she viewed that residence that her and her brother were able to take care of. Your Honor, I think that this is truly described best as Mr. Olson is one of the most serious people that this court could prosecute, taking a then 79-year-old woman throughout the city, causing her so much fear, as well as all of the surrounding circumstances, is why Your Honor should follow the state's recommendation. Thank you.
All right, thank you. We're going to need Mr. Olson unmuted. Mr. Olson, while the deputies come back there to unmute you, I want to let you know that there are factors for me to consider as sentencing. These factors include but also two, to protect the community. I want to go back as to your history, touching upon your character, things such as your age, family, education, work history, and any history of undesirable behavior pattern or things that the court can consider relative to your character, nature of the offense, any mitigating, aggravating factor, and then also the need to protect the community, which may include the need to protect specific individuals and or the community at large. But I'm letting you know that so that when you make your sentencing argument, you are aware of what the court must consider in fashioning a sentence. Okay, so Mr. Olson, as to your sentencing argument.
Well, so first of all, I'd like to object to everything the DA said, if that's possible. Some of the history is wrong, and as far as that case from 2009 in Milwaukee, it was changed for a reason. There was DA misconduct in their case, and the alleged victim never claimed that I stole a car, which is why I shouldn't have been charged. Again, if you could look at the charging document, I was borrowed the car, we lived together, so that case shouldn't even have ever been charged. There was no crime committed, which is why that case went from 5 years to 3 months, and the judge let me out. I believe it was around 3 months of serving that 5-year sentence. He let me out immediately because there was no crime. So everything is being kind of it's being made to look as if it is more than what it really was. And as far as this case, I mean, I've always claimed my innocence, and that there are texts that exonerate me. I'm not the person that they're making me out to be. I'm a kind, caring individual. Anybody that knows me knows that. I've continued to do that in jail, helping inmates that can't read and write, file grievances, file other numerous things just within the jail. Anybody that knows me can vouch for this. Unfortunately, I have nobody here today. This has been very difficult to defend myself, having 2-3 concussions within the last week. And then no help really from my standby. I was told he was going to be helping me and that he could take over for my trial if I couldn't go, but then wasn't allowed to do so. This has been very, very hard to defend myself. And again, anyone that knows me knows I'm a very kind person. This narrative you put out there is completely wrong. And as far as these allegations or investigations, I've never been charged with anything because I did nothing wrong. And that the DA was bringing up from other counties. And I still have not been officially charged with these crimes in Racine that she's bringing up. And again, for these counts, I've always maintained my innocence, and I wish Your Honor would take a look at those unredacted phone download forms that were falsely filed, which proved that there was a text that exonerated me. I've claimed this since day one. I don't know why anyone would make a claim of that sort. And the DA has perjured herself. And so I hope that you take that into consideration. This person should have been charged with filing a false police report, which is why they kept these texts. The DA knows she could never win her case if she gave up this text. This is why I've asked the FBI to get involved to help me prove my actual innocence. And as far as these other cases go, I said I knew those individuals. I knew the individual that owned the RV, and I'm not sure, why I wasn't giving him more of a chance to testify, so I could give him my side of the story. I used to make deliveries to the individual that owned the garage, which is how I knew him, and I was not able to testify to that. I did Uber Eats deliveries to that individual, Instacart deliveries to that individual. There were numerous things that I wasn't able to testify about, which would have made clear more things about why I was how I knew them. But again, my innocence is I've been claiming my innocence since day one. There are texts in this download, which is why she came out with another download. This is it's clear in the transcript, Your Honor, that she withheld the text in January of 2024. Attorney Camrari acknowledged receiving full discovery, and then in February 14, 2024, they revealed they had an unredacted phone version, phone download, which contained text that pertained to my case. And this would also show the communications between my attorney and DA Sadowski. So I'm not sure why none of this was ever investigated by the OLR, Judicial Commission. I've contacted so many people, and even the FBI. I'm asking the FBI to look into this phone download. So, and her, Betty's phone record will show that text is there, but no one would subpoena the phone records by motion number 11.
Mr. Olson, I'm going to interrupt you there because I've allowed you to go way off track here. I already told you what the court must consider as sentencing, and to the extent that I've already addressed your motions, try not to spend your time talking about things that really aren't relevant to sentencing, and even if it's relevant, it has probably very little, it's going to be given very little weight, okay, because those are motions you can file on appeal, or issues rather that you can file on appeal. And so to the extent that the court's goal here as sentencing is to pronounce a sentence that, one, punishes you for what you've done and to protect the community, what are things that you want to argue on your behalf and make sure that I'm aware of?
Well, that I'm innocent, and that's why I was bringing up the alleged victim's phone records. If those simply would have been subpoenaed by any one of my 7 attorneys, that's one simple thing that I asked of my attorney. Just, can you please just subpoena her phone record, since the DA is not giving us the complete phone download? And none of them would do such a simple task. I don't understand why. So this pertains to my innocence. This is huge. I mean, if those texts would have been handed over, or the phone record, her phone record subpoena, and it shows that phone call is missing from the phone download, this blows the case out of the water. Oh, Mr. Olson's been innocent.
Okay, Mr. Olson, I'm going to interrupt you and remind you yet again, if you cannot follow the court's rules relative to your sentencing argument, I think at this time it's proper for me to mute you and then proceed. So let that be your last warning, but please continue with your sentencing argument.
Okay, well, I mean, there's no reason to protect the public. I'm not violent. I'm innocent of these charges. Anyone that knows me knows I'm a kind and caring person. I'm innocent, so I guess I don't know how much of an argument I can make as far as what he sentenced me to charge, to sentence an innocent man to prison. I haven't been in any trouble since for 10 years, and I know the DA brought up a case in 2002 that wasn't even mine. There were some cases that she's bringing up that aren't mine, but I don't remember all of them, what she said. But I mean, I'm not someone that needs to be. The public doesn't need to be protected from me. I've been in the jail here 40 months. I have not one rule violation at all, and that's rare here. Not one fight, not one anything. Lock-ins are given here for any rule violation. I have 0 lock-ins in 40 months. I'm polite, courteous to everyone, just like I am out there. You know, some of my past, 20 years ago, I did have some issues that were drug related, and I always owned up to those, and if I pled guilty to the plea, I did own up to those crimes, and I paid my debt to society, and even more so, I believe I was overly sentenced on a lot of those charges when parole was taken by Tommy Thompson and did more time than necessary for some of those crimes, which were minimal, and I'm not trying to minimize the crimes, but compared to other crimes on that scale, yeah, I did a lot of time for crimes that I shouldn't have. And the escape that is on my record, that is a non-report to a disagent. It is not an escape from a facility or a jail. It is a non-report to a Division of Intensive Sanctions agent. That was a very odd situation. It was just, I didn't report to my PO basically, and they charged me with escape. It was a very odd rule, but there's no need to protect the public from me. I'm a very kind person. The news and the media has put up this narrative in the day that I'm this person that people need protected from. That is completely absurd. And if they knew me, anyone that knows me would testify to that fact. Anyone in the jail, the people that I talk to in the jail, even inmates, nurses, the guards, some of the guards might not like me because I fight for my rights, but they'll definitely say that I never called them foul, I'm polite and courteous. So this narrative that's being put out is way off. And my son, my mother, anyone in my family, aunts, uncles would testify to that. I'm a very good person, and like I said years ago, yes, I had some issues with drugs. The charges, most of them are from 20 years ago. All that I owned up to, and I took responsibility for that, and I paid my debt to society, doing 10 plus years in prison. I guess that's all I have to say. I would hope that a minimal sentence would be placed upon me because of my innocence. I mean, I'm not sure why Your Honor even never looked into. I don't know if you can, but if you take a look at some of the transcripts and the fraudulent documents.
Mr. Olson, I'm going to end you there, okay? Because I think let's have him muted. Now, the other thing I do need to know is credit. Attorney Wasilewski, have you had an opportunity to look at credit?
Yes, Your Honor. It's my understanding Mr. Olson was arrested on November 29th, 2022. He's been in continuous custody since then. I confirmed with Ms. Sadowski that neither of us know of any other sentences or revocations that would apply to any other case than this one. So I believe he's entitled to continuous credit from his arrest date to yesterday, which would be 1,204 days. And I have prepared a form indicating that, which I can submit to the clerk.
Yes, please. I'll take a look at that. All right, thank you. Okay, the credit worksheet, I have no reason to doubt the math is not correct. It looks fine to me. And then considering that Mr. Olson has been in custody since November 29, 2022, $1,204 days will be given as credit. All right, Mr. Olson, as I stated before, sentencing primarily serves two purposes. One, to punish you for what you've done, and the other is to protect the community. Now, the court is to consider the least restrictive means of punishment unless confinement is necessary because you have needs that can only be met in confinement, or if putting you on probation would unduly depreciate the seriousness of the offenses. There are factors for the court to consider, but not that include but are not limited to your history, touching upon your character, as well as the nature of the offense, if there are any mitigating, aggravating factors. And the sentence should be sufficient to deter anyone else from engaging in those same conduct. Now, beginning with your history, you're 55 years old, you have a birthday coming up, so in advance of that, happy early birthday to you. You have a high school, you have a HSED, which you were able to obtain through the local community college. You have a history of substance use and abuse, which you stated as well in your sentencing argument. And during this trial, of course, I did learn that you're a father, and I believe, if I heard you correctly, that you're also a grandfather. But certainly you're a father, you're a son. And I emphasize that because one would think that if someone has those type of relationships, that some reasonable consideration would be given to those in the public, in our community. You do have employment history, most recently working independently as an Uber driver. And with respect to your knowledge of and involvement with the criminal justice system, certainly you have a long history. To the extent that the state talked about other cases that you were not charged, Mr. Olson, the court will only consider it to mean that you are no stranger to the criminal justice system. Relative to the pending cases in Racine County, you're presumed innocent until proven guilty. Thus, there's no conviction in those cases, those pending matters. But to the extent that they touch upon your character relative to your experience with the criminal justice system, the court may and will consider it. Your history is quite extensive, and it is alarming that you have such a long history. You've done so much time in custody, yet your behavior, your criminal behavior, just doesn't cease. And many of these crimes do speak very poorly of your character, of you not being able to be a community member that the community can reasonably trust and expect reasonable behavior. And it's disconcerting. And because, in part, the crime for which you're being sentenced today involves an elderly person. And so your decision to engage in criminal conduct to inflict harm on others isn't limited to just the young and able, but you certainly have expanded that to the elderly and immobile. Your behavior throughout the pendency of this case, such as your refusal to accept court decisions despite being warned and told numerous times that you may not like the court decision, but you can certainly appeal it. Once the court has made a decision, you move on. You refuse to follow those rules, as well as other rules. You continuously disrupt the court, and your antics to achieve your goal of protracting this case. This case has been pending for quite some time. You went through 7 attorneys, and so not only are you a difficult person to work with in court, as well as by reading the lines, the fact that you went through 7 attorneys, but your behavior towards the victim during the time that you had confined Ms. Hennell. And so that takes me to the nature of the offense here. I'll first start with the mitigating factors, because there are actually some mitigating factors in this case. You did, as the state pointed out, allow the victim to escape physically unharmed. However, though, the psychological and emotional trauma you inflicted is without a doubt everlasting, as she herself testified at trial. The amount that were charged without authorization, without permission, I think in the big picture here, those amounts were not large amounts. Some of the items recovered may not have been returned to the victims yet, but nonetheless, they have been recovered. I believe the bike was recovered, correct, State? Because that's when law enforcement observed him with a bike. The phone was tossed along the road, and that was recovered. That's
correct.
That's correct, right?
Yes.
And so, to the extent that those items have been recovered, eventually, probably at one point, those items could be returned to the victims. And so, it's not a total loss in that regard. So those are the mitigating factors. As to the aggravating factors, the victim here, one of 3 victims, but the first one, Ms. Hennel, she was 79 years old at that time. And I know that there was evidence that was brought in by way of testimony indicating that today her mobility is much more limited than it was back then. But nonetheless, she had limited mobility. And for at least 15 hours, you held Ms. Hennel against her will, without her permission. You held her captive, and you inflicted emotional and psychological trauma. The one thing that has stayed with me to this day is when Ms. Hennel testified and explained that during the time that she was with you, Mr. Olson, she thought about how to escape and whether she can escape. And for someone in that moment to know that the door is also close, like freedom is so close, but yet not within grasp. She couldn't trust herself that she could get away from you. That emotional, psychological trauma, I just can't imagine the depth of that trauma. But to this day, and through her testimony, that still haunts her. In addition to that, she, of course, herself testified that on a daily basis, she relives this incident and is able to recall this incident. And so the harm that you've inflicted on her is extensive, no doubt. I don't doubt that for 1 minute. But what was, I think what was disconcerting, and I think at a greater level, emphasizing the need to protect the community beyond the 3 victims in this case, is the fact that when you subjected Ms. Hennel to this harm, and she tried to flag down help, that the first person who saw her told her that that person cannot help her because they had a turkey in the oven. So she was turned away from help when freedom was so close, and yet turned away. And I'm sure that reinforced her belief that she could not escape. So it made it so much more persuasive why she felt so helpless and hopeless. Because in fact, at the end, she was refused help because somebody had a turkey in the oven. It's just beyond words, the harm that you subjected this victim to. And on top of all of that, you talk about your mother. Ms. Hennel is someone's mother as well. But that consideration you did not extend to Ms. Hennel. And that emphasizes how important it is, the need to protect the community, because you cannot extend that reasonable consideration to anyone else in the community but yourself. That puts the community at risk, and it puts the community on edge. You used the victim's phone, then you discarded it. You used the victim's bank card, and it was found on your person. You made purchases without permission, albeit I did count as a mitigating factor the fact that the amounts that were charged were more or less nominal. But nonetheless, you had no permission to use her bank card. You entered properties without permission. You damaged property in the course of doing that. You defecated in someone's RV when that RV had been winterized. All that takes time and money. And also, when law enforcement approach you, and I forgot the word exactly that the officer used when he testified, but I'll just basically describe it as quiet resistance. You were on your knees, but you failed to, and you refused to fully follow the instructions, which is not inconsistent with your behavior in court. When I asked you if you can follow the rules, You would give a long statement before you would say, well, I guess, well, you're the boss. It's a yes or no, and you know that. But that's consistent. That behavior is consistent with the resistance that you gave to the officers on that day. The amount of resources used by you, not just with one jurisdiction, Greenfield, but you extended that to Franklin. And those resources could have been used to address important needs in the community, but yet, because of your criminal conduct, your criminal mindset, that you unnecessarily used up all those resources. Considering all these factors, the court will sentence you in the following way. I agree with the state that this has to be a consecutive sentence because each offense is a distinct harm that you've inflicted on the community, and it has to be recognized for that. With respect to count 1, initial confinement, 240 months, extended supervision, 180 days, consecutive to any sentence you may be serving. Count 2, 36 months in, 36 months out, consecutive to count 1. Count 3, 9 months, that'll be consecutive to count 2, and that's 9 months in the jail, but the DOC will do its math on that relative to your placement. Count 4, 60 months in, 36 months out. And that's consecutive to count 3. As to count 5, 60 in, 36 out, consecutive to count 4. You're not eligible for boot camp by virtue of your age, but you're not eligible for programming additionally. And so that's the court's sentence. As to conditions of supervision, they are as follows. AODA assessment and comply with recommended treatment. Absolute sobriety, no illegal drugs or alcohol, prescription drugs without a valid prescription, random drug testing. A refusal is the same as a positive. You're to obtain, maintain employment. No new law violations rising to the level of probable cause. You are to successfully complete any programming deemed appropriate for you by your agent and to cooperate fully with your agent. You are to undergo any cognitive behavior programming, including but not limited to thinking for a change. You are to undergo mental health assessment and comply with any recommended treatment. And you are to complete a financial literacy class. Mandatory court costs, assessments, and fees shall be paid by the end. Actually, give me a minute here. Shall be paid in full within 24 months. Any remaining balance at that point will be docketed against you as a civil judgment. DNA sample is ordered. Non-mandatory costs will be waived due to indigency. You do have the right to appeal my decision. Your attorney will you do have the right to appeal my decision. There will be a Counsel, Attorney Wasilewski, is there a form in front of you or at your table, a notice of appeal?
I don't have such a form. However, I can state that Mr. Olson has expressed the desire to appeal, and I told him if the court allowed, I would file the necessary notice of intent to start the appeal, so I can state that on the record. I'll take responsibility to see that his appeal process is initiated.
Okay, thank you. You may do so. The notice of right to seek post-conviction relief shall be provided to Mr. Olson. Mr. Olson, if you want to appeal, you have to do that within 20 days. Otherwise, it is difficult for you to appeal.
Your Honor, can I just ask a clarification question?
Yes.
On count one, you said 240 months in custody and 180 days extended supervision?
180 months.
Okay.
Did I say days again?
Yeah.
I meant 180 months.
Considering the discussion regarding months, I was wanting to make sure.
Yes. Okay, thank you for that clarification. Anything else I may have missed today, State?
Not that I noted.
Okay, and I'm aware that Mr. Olson is trying to get the court's attention, so we'll have him unmuted. My first question to you, Mr. Olson, is there anything that I may have missed that you believe I need to address now?
So I just wanted to make sure that I'm appealing, that the court knows I'm definitely appealing. I'm innocent, always maintain my innocence, and I'd like Attorney Wazowski, as you just stated, to maybe come back today, go over the appellate process with me, either right now or when you get to jail. I also need to get on the record that when the microphone throughout the trial was turned off and I was not allowed to object. So the whole purpose of appealing is based on being able to object. If they don't find objection.
Okay, Mr. Olson, is there anything that I may have missed relative to pronouncing a sentence that I need to cover on the record? So we talked about initial confinement, extensive supervision as required by law, the bifurcated sentence. I issued conditions. I also gave you your notice of right to appeal, and I've indicated that Attorney Wazowski may assist you in putting in that initially that appeal in, and that you be given the notice of post-conviction relief form, which every defendant is given after sentencing. Is there anything else I may have missed? And that really goes towards procedure.
Well, I mean, as far as the sentence, I believe that is extremely harsh, considering that I'm innocent. Not only that, let me restate that I'm innocent, but there are people that get sentenced every day for murder.
Mr. Olson, you can bring that up with the Court of Appeals. You're not making good use of the time that the court is allowing you. Again, the question was limited to procedural things I may have missed. Let's have him muted.
Well, you're being prejudicial and biased, because of the misconduct of
Deputy, mute him.
Bribing the judge.
Okay. All right, Mr. Olson is muted. From what I can understand, he did not have anything that he wanted to point out that I may have missed in the course of pronouncing my sentence. Okay, restitution is set to 0 as none is requested. All right, thank you, everyone. This hearing is concluded. Yes,
one
counsel?
question.
Yes.
Just before Mr. Olson was removed from the courtroom the last time, he pushed this envelope towards me. It's a clear Ziploc bag. There is one flash drive in it that's visible, and then there is a paper envelope inside that feels like it has perhaps 2 more flash drives. And he directed me to make this part of the record, and I am frankly not sure what that means or what to do with this envelope. I guess the options are the court could accept it as an exhibit. The court could direct me to hold it for appellate counsel. The court could direct it be returned to Mr. Olson's property for him to do with what he will. But it's sitting here now, so I just...
Deputies, please return that to Mr. Olson. He can do what he wants with that.